Hello student, welcome to the lecture on the Hotelkeeper and the laws of torts and negligence. And after this lecture, we will be able to learn the following objectives. Discuss the relevance of motive in determining the liability for a tort. Describe the false imprisonment. Understand malicious criminal prosecution. Define vicarious liability. Discuss the recip salicutor. Explain the tort for liability. Let's start with a brief introduction. The piecemeal development of civil liability under the forms of action, little thought was given by early common lawyers to the existence of any general principle underlying the various examples of liability. As late as the latter half of the 18th century, Blackstone in his commentaries on the laws of England described trespass in the case as a universal remedy given for all personal wrongs and injuries without force thought in terms only of the form of action, not of the substantive grounds for allowing the action. Similarly, the authors of Digest and Abridgments, early types of practitioner texts, were concerned only to provide examples of factual situation where liability had been held to exist and to state the correct form of action in which to plead those facts. Let us now discuss the relevance of motive in determining the liability for a tort. As a general rule, malice or evil motive is not relevant to determine a person's liability in torts. An unlawful act does not become lawful because the motive is good. Similarly, a lawful act does not become unlawful because of bad motive. Motive means the reason behind the act or conduct or an object to be achieved in doing in an act, whereas means evils, motive or bad motive or ill will. Salmon described motive as the ulterior intent. Generally, motive is irrelevant in tort. A person cannot be liable in tort on the ground of evil motive, bad motive, if the act itself is not unlawful. Evil motive or malice on the part of defendant is one of the essential elements to be proved by plaintiff in respect of torts, namely deceit, conspiracy, malicious prosecution, and injurious falsehood. Different types of torts. There are three kinds of torts: intentional torts, negligent torts, strict liability torts. Intentional torts. The analysis of most intentional torts is straightforward and parallels the substantive crimes. When physical injury or damage to property is caused, there is rarely debate over the liability if the plaintiff deliberately undertook to produce the harm. Intentional infliction of emotional distress. Until recently, the common law rule was that there could be no recovery for acts even though intentionally undertaken that cause purely mental or emotional distress. For a case to go to the jury, the court required that the mental distress result from some physical injury. In recent years, many courts have overthrown the older rule and now recognize the so-called new tort. In an employment context, however, it is rare to find a case where a plaintiff is able to recover. Trespass and nuisance. Trespass is intentionally going on land that belongs to someone else or putting something on someone else's property and refusing to remove it. This part of tort law shows how strongly the law values the rights of property owners. The right to enjoy property without interference from others is also found in common law of nuisance. Intentional interference with contractual relations. Tortious interference without contract can be established by providing four elements. Number one, there was a contract between the plaintiff and a third party. Number two, the defendant knew of the contract. Number three, the defendant improperly induced the third party to breach the contract or made performance of the contract impossible. And number four, there was injury to the plaintiff. Malicious prosecution. Malicious prosecution is the thought of causing someone to be prosecuted for a criminal act, knowing that there was no probable cause to believe that the plaintiff committed the crime. The plaintiff must show that the defendant acted with a malice or with some purpose other than bringing the guilty to justice. Negligence tort. Negligence in tort has several meanings. It may refer to the tort of negligence or it may refer to careless behavior. It is in the latter sense that the word is used here. In this sense, it does not refer to a state of mind. When a court finds that a person has been negligent, it is making an ex post assessment of their conduct. The tort of negligence has four elements: a duty of due care that the defendant had, the breach of the duty of due care, connection between cause and injury, and actual damage of lost.
As we study tort law, it becomes very clear that there are some striking differences between the tort of negligence on the one hand and the intentional torts on the other. So in this lecture, I'd like to discuss the two main differences between negligence and the intentional torts. It might help to look at the elements of some of these torts. First, let's review the elements of negligence. Now, in general, the elements of negligence are, number one, duty, which is the obligation to use reasonable care to avoid injuring the plaintiff; breach of duty, which generally speaking amounts to the failure to use reasonable care; proximate cause, which is the legal responsibility for bringing something about; and harm, that is the actual loss or damage that results from the defendant's failure to use reasonable care. Now, the intentional torts all have various elements, so let's look at a couple of examples of intentional torts to get an idea of how they differ from negligence, and then we'll get into the specifics of the two major differences. For instance, let's look at the elements of the tort of assault. The elements of assault are: the defendant attempts to make unconsented, harmful, or offensive contact with the plaintiff; the plaintiff is actually apprehensive for his or her safety; and the threat of such contact is imminent. As another example of an intentional tort, let's look at the elements of false imprisonment. This is an interesting one. False imprisonment requires confinement without the plaintiff's consent, the defendant's intent to confine the plaintiff, confinement for an appreciable period of time, no reasonable means for the plaintiff to escape from confinement, and in some jurisdictions, the plaintiff's knowledge or awareness of the confinement. So we've looked at a couple of different examples of intentional torts, and we've looked at the elements of negligence. You might already have figured out the number one difference between negligence and the intentional torts. The main difference is intent. With negligence, there's no requirement that the plaintiff prove the defendant intended any harm. Negligence amounts to acting unreasonably under the circumstances and thereby causing harm to someone. By contrast, a person commits an intentional tort against a plaintiff when he or she either specifically desires to injure the plaintiff or knows that injury was substantially certain to result from his or her act, but engaged in the act anyway. It might sound redundant, but you need to remember that intent is an element in all the intentional torts. The second major difference between negligence and the intentional torts is that while punitive damages may be appropriate under some circumstances when you have an intentional tort, the general rule is that punitive damages are not available for acts of simple negligence. Punitive damages are awarded over and above compensatory damages, and they're designed to punish the wrongdoer and to deter similar behavior on the part of the defendant or others. So it really wouldn't seem to serve any societal purpose to try and punish somebody for an act of simple negligence, no matter how serious the injury.
Standard of care. Not every unintentional act that causes injury is negligent. If brake it to a stop when we see a child dart out in front of car, and if the noise from tires gives someone in a nearby house a heart attack, we have not acted negligently toward the person in the house. Duty of care and its breach. The law does not impose on us a duty to care for every person. If the rule were otherwise, we would all in interdependent world be brothers keepers, constantly unsure whether any action we took might subject us to liability for its effect on someone else. The law copes with this difficulty by limiting the number of people toward whom we owe a duty to be careful. Strict liability. Strict liability is the imposition of liability without fault for damages on the defendant. This is different from negligence, as the burden of proof is not placed on the plaintiff to prove that the damages were a result of the defendant's negligence, only that damages occurred and the defendant is responsible. In strict liability, there is the assumption that the manufacturer or supplier was aware of the defect before it reached the plaintiff. Strict liability for products. Products liability is extremely important. Strict liability may also apply as a legal standard for products, even those that are not ultra hazardous. In some national legal systems, strict liability is not available as a cause of action to plaintiff seeking to recover a judgment of products liability against a manufacturer, wholesaler, distributor, or retailer. Assault and battery. One of the most obvious intentional torts is assault and battery. Both criminal law and tort law serve to restrain individuals from using physical force on others. Assault is the threat of immediate harm or offense of contact or any act that would arouse reasonable apprehension of imminent harm. Battery is unauthorized and harmful or offensive physical contact with another person that causes injury. Assault. Assault means conduct or threat to apply violence on the person of the plaintiff in circumstances that may create apprehension that the latter is in real danger. It is committed when a person threatens to use force against the person of another, thus putting the other person in fear of immediate danger. Battery. Battery means the actual application use of force against the person of another without lawful justification. It is immaterial whether the force is applied directly or indirectly to the person, but there must be actual bodily contact between the plaintiff and the defendant.
At McGregor & Unwine, we have represented clients in assault and battery cases for the last 25 years. Assault cases can be filed as both felonies and misdemeanors. Assaults involving weapons, such as guns, knives, or assaults involving serious bodily injury are generally filed as felonies. Assaults involving no weapons and no injuries or minimal injuries are generally filed as misdemeanors. Battery is a closely related offense that is a misdemeanor unless involving serious injury. Anytime a client comes to our office charged with assault and battery, the first thing we try to understand is whether or not the client is actually guilty of the offense. Is there sufficient evidence to prove that the client was the perpetrator of the assault? Is identification an issue? Was the client acting in self-defense or defense of others? If you are presently under investigation for assault and battery, early intervention with the DA, the prosecutor, can help. We may very well be able to convince them to reduce the matter to a misdemeanor prior to filing. If a criminal charge is filed in court and it is a felony, we can petition the court to reduce the matter to a misdemeanor. If you are facing misdemeanor assault and battery charges, there are a number of options to avoid a criminal conviction. These can include deferred entry of judgment, which would result in a dismissal of the charge, diversion, or a civil compromise agreement.
Let us now discuss false imprisonment. False imprisonment means total restraint or deprivation of the liberty of a person without lawful justification. The duration of the time of detention is immaterial. False imprisonment may be committed even without the plaintiff's knowledge, example by locking him up in his bedroom while he is asleep and then reopening the door before he was awoken. In such a case, the plaintiff may still sue. Slander and libel. Slander. Slander takes place where the defamatory statements are made in non-permanent form, example by word of mouth, gesture, etc. Slander is actionable only on proof of damage. Libel. Libel takes place where the defamatory permanent form, example writing, printing, television, broadcasting, effigy, etc. Where a defamatory matter is dictated to a secretary and she subsequently transcribes it, the act of dictation constitutes a slander, while the transcript is a libel.
Have a seat, Mr. Walker.
So I want to sue the guy that called me a car thief. I hear that's called defamation, and I want $1 million.
Okay, before we can talk about how much to sue him for, we need to figure out if the statement was defamatory and what type of defamation it was. The kind of defamation it was can have a big impact on how much you can recover.
Okay. What do you mean by types of defamation?
There's basically two kinds, libel and slander.
Ah, I've heard of both of those. Did not realize they were defamation.
Yes, that's true. Libel is written defamation and slander is spoken defamation. Now, you said this guy called you a car thief. How did he make this statement?
He wrote it in the paper.
In the paper.
The local paper. $1 million, that's what I want. And an apology. I want $1 million and a great big apology.
Let me tell you a little bit about proving a defamation case so you know what you're facing.
What I'm facing? I was defamed. In fact, I think I was even libeled a little bit. You said it was in writing.
To prove a defamation case, we must prove that the defendant made a false statement that injured your reputation, that the statement wasn't privileged, and that it was communicated to someone other than you.
Yes, and we have all that. I say we sue.
First things first. You said he called you a car thief. Was this in a letter to the editor, an article, or in an editorial written by someone at the paper?
I don't see how this matters.
As I mentioned, there are some communications that are privileged. Lawmakers, for instance, and judges that sit on the bench can say things in session without being sued with things that might otherwise be defamatory in other situations. If this statement was made in the context of a news report, most reporters know to say something like, "Police report that Mr. X was arrested for car theft." You know, that kind of thing.
Oh. No, it was not written in an article. It was written in a letter to the editor by Mr. Joe Bishop. So I am going to own his house, his car, and I'm going to have him fired for what he wrote.
First things first, let's go through this point by point. What did Mr. Bishop say?
I knew you were going to ask that. And because I knew you were going to ask that, I brought a copy of the article. Give it a read.
Let me see. Well, it does mention you by name. Let's see. It also says that you are a car thief.
Ah, seen enough? You know, I'm kind of thinking at this point that $1 million might not be enough. You want to go for $2?
There's something else in here that bothers me.
And what's that?
It says here that you have been convicted of stealing cars. Is that true?
I did plead guilty to car theft a couple of years ago. But that was a couple of years ago. It's been a while since I've even looked at a car.
Well, you might remember what I said, that defamation is a statement
Yeah.
about you
Yeah.
that injured your reputation.
Yeah.
But the statement also has to be false.
What?
This statement is true, so it isn't defamation.
It's not even slander.
It's not any kind of defamation. You pled guilty to car theft, and I'm afraid that makes you a car thief.
I would watch your step, miss, because I might get you for slander. Good day.
Good day.
Defamation. The term defamation means injury to the reputation or character of a person. According to Winfield, defamation is a publication of a statement which tends to lower a person in the estimation of right-thinking members of society generally, or which tends to make them shun or avoid the person. A defamatory statement is one which is false and lowers a person's esteem in the community or subjects a person to hatred, contempt, or ridicule. Defamation involves speech that damages the reputation of the victim. Justification or truth. Justification or truth in a civil action for defamation, truth of the defamatory matter is complete defense. The reason for this defense is that the law will not permit a man to recover damages in respect of an injury to a character which he either does not or ought not to possess. Fair comment. Fair comment making. Fair comment on matters of public interest is a defense to an action for defamation. For this defense to be available, the following essentials have to be fulfilled. Privilege. There are certain occasions when the law recognizes that the right of free speech outweighs the plaintiff's right to reputation. The law treats such occasion to be privilege, and a defamatory statement made on such occasion to be privilege, and a defamatory statement made on such occasion is not actionable. There are two types of privilege: absolute privilege and qualified privilege. Let us now discuss malicious criminal prosecution. Malicious criminal prosecution may be the institution against an innocent person unsuccessful criminal proceeding with a reasonable and probable cause and in a malicious spirit, that is, from an indirect and improper motive and not in furtherance of justice and causing damage to the plaintiff in person, pocket, or reputation. malicious prosecution, as well as any other abuse of legal process which injures the reputation of the party is actionable in torts. Trespass to land. Trespass as a wrong has a very wide application. It could mean unlawful presence in another closure or land or premises, offense to the body of a person, or even mean wrongful taking of goods or chattels. Remedies for trespass to land. Defense of property, expulsion of trespasser, especially in case of continued trespass, distress, damage, pheasant, damages, injunction, action for recovery of land, defenses against trespass on land, statutory authority, entry by license, adverse possession, act of necessity, by order of court of law, self-defense, re-entry on land, retaking of goods and chattels. Vicarious liability. Vicarious liability means the liability of one person for the torts committed by another person. The general rule is that every person is liable for his own wrongful act. However, in certain cases, a person may be made liable for wrongful acts committed by another person. Master and servant. A servant means a person employed under a contract of service and acts on the orders of his master. The master therefore controls the manner in which his work is done. The concept of vicarious liability is based on the principle of equity, that employee is normally people of meager resources, and it is therefore only fair that the injured person is allowed to recover damages from the employees. Therefore, a master is liable for the torts committed by his servant. Wrongful act. The act complained of should, under the circumstances, be legally wrongful as regards the party complaining, that is, it must prejudicially affect him in some legal right. This must be an act or an omission. Merely that it will, however, directly do him harm in his interest is not enough. The act being wrongful in law is called atrus. Negligent act. Liability for negligent acts does not always end up with the one who was negligent. Under certain circumstances, the liability is imputed to others. Legislature in many states have enacted laws that make people vicariously liable for acts of certain people with whom they have a relationship, though not necessarily one of agency. Recips liquidator. As a general rule, the burden of providing negligence lies with the plaintiff. However, in certain cases, a plaintiff's burden of proof is relieved by the doctrine of recip saliquid, where it is applicable. Recip saliquid means that thing or fact speaks for themselves. Recip saliquid is a rule of evidence and not of law. Effects of recip saru. It provides prima facie evidence of negligence on the part of the defendant. It shifts the burden of proof from the plaintiff to the defendant. The plaintiff has suffered injury to his person or property. Plaintiff has to provide that if it were not of the defendant's act, he would not have suffered loss or damage. Defenses to negligence. Contributory negligence, volante non-fit injury, statutory authority. Corporation's capacity to sue. A corporation can sue and can be sued just like an individual. A corporation can be sued for the wrongs committed by its employees during the course of employment or acting as agent for the corporation. But it is to be noted that the corporation can't only be sued for the wrongs committed during the course of employment and not any duty which the employee performs as an individual at his home or a place other than his office, or simply not in his course of employment. Government. Government can never be sued while performing tasks mentioned under the statute. However, government can sue and can be sued like a single person by the name Union of India or State of X. Person having judicial powers, that is, a judge, cannot be sued for his judgment when he is acting within its capacity. A tort is a legal term describing a violation where one person causes damage, injury, or harm to another person. The violation may result from intentional actions, a breach of duty as in negligence, or due to a violation of statutes. The party that commits a tort is called the tortfeasor. A tortfeasor incurs tort liability, meaning that they will have to reimburse the victim for the harm that they caused them. Joint liability. This is where several tortfeasors are held liable for a tort against one party. The tortfeasors are said to be jointly liable for the harm. Several liabilities. If two or more defendants are found liable for an indivisible injury, the defendants will be held jointly and severally liable. This means that each defendant is liable for the entire award regardless of the individual degree of fault. Vicarious liability, there is where a superior is held liable for the actions of their subordinate. Respondent superior, under the doctrine of respondent superior, an employer is liable for an employee's torts, including intentional torts, if the employee was acting within the scope of employment. Independent contractors, in contrast, a defendant who engages an independent contractor is not liable to others for the acts or omissions of the independent contractor. An independent contractor is a person who performs services for another person under an express or implied agreement and who is not subject to the other's control or right to control over the manner and means of performing the services. Now, in the end, let us summarize what we have learned in this lecture. The tort of false imprisonment originally implied a locking up as in a prison, but today it can occur if a person is restrained in a room or a car, or even if his or her movements are restricted while walking down the street. Malicious prosecution is the tort of causing someone to be prosecuted for a criminal act, knowing that there was no probable cause to believe that the plaintiff committed the crime. Assault means conduct or threat to apply violence on the person of the plaintiff in circumstances that may create apprehension that the latter is in real danger. Slander takes place where the defamatory statements are made in non-permanent form, example by word of mouth, gesture, etc. Defamation is the publication of a statement which tends to lower a person in the estimation of right-thinking members of society, generally, or which tends to make them shun or avoid the person.